Hi friends, my name is Isha and welcome to Lawn Looks, where I smoosh together law and makeup and talk about some of the more interesting and fun cases I learned about in law school while doing my makeup. Quick disclaimer, nothing I say should be construed as legal advice. I cannot give you legal advice. If you do need legal advice, please obtain your own attorney and obtain advice from them on any particular matter, not from me. Okay, I think we're ready to get started. Round and around and around and around she goes. I have a very entertaining case for y'all today. Today's case involves cats and a wonderful, beautiful descent. The name of the case is Nahrstedt versus Lakeside Village Condominium. The facts of this case are pretty simple. There's this woman, Nahtore, I think that's how you say her name, Nahtore Nahrstedt. Miss Nahrstedt has 3 cats, Boo Boo, Dockers, and Tulip. Such cute names for cats, I love it. And she loves her cats. They celebrate Thanksgiving together on each of their birthdays. They eat off of a plate that has their name inscribed on it. It's adorable. And Miss Nahrstedt is living in a condo with these 3 cats, but the condo that she's living in, she has signed essentially a covenant. We won't get into that. This is a property case about covenants. Yeah, I don't want to talk about it. But with her condo, she has a restriction that is enforced by the homeowners association that the only pets they can have are birds and fish. They're not allowed to keep cats or dogs because it would hinder the enjoyment of neighbors. So say you had a dog, you're not allowed to have a dog because it would be too noisy for your neighbors. So technically, she's not allowed to have these cats. Here's the thing, her cats aren't really hurting anyone. I don't think her neighbors ever really noticed until somebody peeked into her apartment and they noticed the cats there. So the homeowners association decided to enforce this restrictive covenant, that's what it's called, to not allow the cats in the apartment. So naturally she sues because she wants her cats to stay. If you can't tell, I'm a cat lover, pet lover really. And why wouldn't you want Boo Boo, Dockers, and Tulip to stay in your condo? Those sound like dope cats. Let them stay. But no, alas, 'twas not meant to be. So she's sued, and I can't get this palette open. And oh, there we go. She lost a trial. She appealed. She won at the Court of Appeals. And the Homeowners Association then appeals, and it goes up to the California Supreme Court. We're in California. And she loses there as well, unfortunately. In the end, she was not allowed to keep her cats with her in the condo. The California Supreme Court majority said that she can't keep her cats. But I don't want to talk about the majority. I want to talk about the beautiful, beautiful dissent that was written. So this dissent starts out with probably the best quote in any legal opinion that I have ever read. I forget who the quote's by. I think it's Albert something or other. But the dissent starts out with, "There are 2 means of refuge from the misery of life: music and cats." That's how it starts out. You already know, that's the setup. So you know this is going to be a great read. It's going to be a fantastic read. I want to do green, I think. I'm going to do green. Then the dissent goes on to say, and this is still in the introduction, this judge says, "In my view, the resolution of this case well illustrates the conventional wisdom and fundamental truth of the Spanish proverb, 'It is better to be a mouse in a cat's mouth than a man in a lawyer's hands,'" which, yikes. The dissent continues along this path, basically talking about how the companionship of a pet is so important and part of human life in such a significant way that this restrictive covenant is indeed too restrictive and unreasonable. One of the main reasons that the majority found for the homeowners association and not the cats is because generally courts enforce covenants unless they're unreasonable, and they found that this covenant is fairly reasonable. Also, the majority found that there's no burden. What else? The restrictive covenant isn't arbitrary in any way, and it doesn't violate any like fundamental public policy. The dissent, on the other hand, says that, you know what? This covenant does actually impose a burden that far outweighs the benefits and value. There is inherent value in having an animal companion to human life, and this restrictive covenant is depriving the humans living in this condo that benefit. So the dissent says, while the majority is technically right, they also just have too narrow of a view that harms the human spirit in the name of efficacy, which I agree with. Want to smoke out my eyes a little bit? Give it a slight cat eye effect. I'll see myself out now. That's the basic gist of the dissent. It has amazing little quotes peppered in here and there, and it's written wonderfully. There's one particular paragraph that I love. He says, "Throughout the ages, art and literature, as well as mythology, depict humans in all walks of life and social strata with cats and dogs, illustrating their widespread acceptance in everyday life. Some religions have even incorporated them into their worship. Dogs and cats are also admired for the purity of their character traits. Closer to home, our own culture is populated with examples of the well-established place pets have found in our hearts and homes." But I was curious, who is this awesome judge who's written this fantastic opinion that I got to read in Property? I'll tell you. His name was Armand Arabian. He unfortunately passed away in 2018 at the age of 83. He served on the California Supreme Court for 6 years, 1990 to 1996. So he didn't serve very long, but he was extremely impactful. Before he served on the California Supreme Court, he served in trial courts and the Court of Appeals, and he was extremely influential in some of the biggest sexual assault and rape law reforms. Most notably, in 1973 at trial, he refused to give a particular jury instruction which asked the jury, or told the jury, to treat the victim's testimony skeptically. He thought that that was a particularly sexist and just bad instruction. The instruction came from the, I guess, concept, or from the policy that a rape charge is easily made and once made difficult to defend against, and Judge Arabian was like, no. So that's pretty cool. And he was a noted expert in this field and pretty well respected. He also wrote a memoir. I'll link it down below. It's called From Gravel to Gavel. And the reason his memoir is titled that is because he was born to Armenian immigrants. His parents fled Armenia in 1915 following the Armenian Genocide. And the gravel part of the title of his memoir comes from the fact that the period in the genocide when the Turkish oppressors forced their victims to hammer stone boulders into gravel to create a foundation for the placement of railroad ties for the proposed Berlin to Baghdad railway. After performing this slave labor, many were then marched off to their graves. I know many of you have probably heard about the recent ongoings on the Armenian and Azerbaijani border, and when I was reading about that, I realized I didn't really know much about the Armenian genocide and about world history really, so I took the opportunity to learn more about it and found out actually that Turkey refuses to acknowledge that what happened to the Armenian people was genocide, even though it fits the definition. In fact, the man who coined the term genocide, Raphael Lemkin, was so moved by what happened to the Armenian people that he came up with the word genocide. The reason we have the word genocide is because Lemkin studied what happened to the Armenian people and coined the term. It's also the second most studied genocide after the Holocaust. And while the US and other Western countries have acknowledged that this was a genocide, Turkey still has not, and many Western politicians and leaders, while the country, so to speak, has acknowledged and called it a genocide, politicians still refuse to call it a genocide, which is problematic. So I just wanted to highlight that while I'm highlighting. I encourage you all to read more about it. I know we got a little bit heavy. I'm sorry about that. We started off with cats, but I'm just a very curious person by nature and I love learning about things. So I figured I would tell you guys all the stuff that I learned while revisiting this super fun cats case. Why I ever try to put on false lashes is beyond me. It never works well for me. Oh my god, I think I put them on like this one was supposed to go on this side and this one's supposed to go on this side. Oh well. Anyway, I encourage you all to learn more world history. And as for Miss Nahrstedt, I think she ended up moving with her cats. That's the only... If you're gonna go through an entire legal case about your cats, it's more than likely that you're going to, and you lose, you're gonna move away so that you can keep your cats as opposed to giving up your cats. So my best bet is that she moved away and had a fantastic life with Boo Boo, Dockers, and Tulip. Oh, that feels good. And that, my friends, is Nahrstedt versus Lakeside Village Condominium. Thank you so very much for watching, and I hope you have a fantastic day, and I will see you all next time. Bye!